Hello, good afternoon or good morning, depending upon where you're at. I am Tony Vernetti, the president and founder of FEDS, Federal Employee Defense Services. I want to thank you for attending today's webinar on Federal Employee Professional Liability Insurance. Before we get started, just a little information about me. I am a former federal employee myself. I was an attorney for a federal law enforcement agency for many years, and then I worked many years defending federal employees at my old law firm, Shaw, Bransford, and Roth, where I was a partner and had the pleasure and honor of defending federal officials at a variety of different agencies. Today, you will learn about the administrative, civil, and criminal exposures you face as a federal employee, and about the professional and financial risks associated with your federal employment, and how federal employee professional liability insurance works and the coverage it provides. Essentially, everything you get for your $270 annual premium or $135 if you're eligible for the reimbursement. These seminars typically take about an hour and a half, but we realize that you just don't have that kind of time to spare, so we created this abbreviated version. I have a lot of material to get through in 15 or 20 minutes or so, so I'm going to ask for everyone to hold their questions until the end, and then I promise I'll stay on as long as necessary to get every one of those questions answered. So liability exposure vulnerability for federal employees really began way back in June of 1971 with the Supreme Court decision called Bivens, allowing federal employees to be sued personally. So in response to this ruling, this was the first time the Supreme Court had said that employees can actually be sued and liable for doing their federal job. In response to this, the concept of professional liability insurance was essentially created, and also Congress enacted legislation for agencies to have to reimburse all managers, supervisors, and law enforcement officers up to 1/2 of the cost of the liability insurance, because they acknowledged and they recognized that these exposures existed for federal employees, and they couldn't completely cure it with legislation in light of the Bivens decision by the Supreme Court. So they wanted to share the burden, and this is pretty significant because they really, in giving up their money to pay for half of it, they're really telling you that they want you and they feel that you need to get this type of insurance. So the PLI is affordable and available to all federal employees, and we will identify in a few moments those positions that we feel are most at risk. Just want to emphasize that the partial reimbursement, however, is only available to managers, supervisors, and law enforcement officers. If you have any question about that, you should just reach out to your agency's HR department or give us a call. We may have your agency's reimbursement policy, and we can provide clarification on that. You should also know that the policy was originally designed only to cover the civil exposures if you're sued personally. Then shortly thereafter, the policies were expanded to cover attorney's fees for investigations, disciplinary actions, and criminal cases, really in response to the increased scrutiny associated with your federal job. Given the enormous responsibility of the federal government, it is virtually impossible for us to identify each and every position that is vulnerable. But if we had to articulate some categories, here are some for you to take a look at. The potential liabilities that exist and the reasons for which federal employees purchase professional liability coverage can really be different depending upon the type of job you have, the position you hold, or your employing agency. On the screen here, these are some of the federal employees that we have identified as having specific exposure and needing professional liability insurance. Again, obviously it's impossible for us to identify each and every position or possible scenario where liability exposure exists, but it's our hope today after the presentation that you yourself should be able to identify your own exposure by the end, again, of the webinar. Now, depending upon the nature of your work, your primary exposure may be administrative, meaning you're exposed to public scrutiny demands, accountability, or a number of allegations that could lead to some sort of misconduct investigation. Or you could be opposed to civil actions or even criminal investigations. So let's think of professional liability insurance in terms of three categories: civil, administrative, and disciplinary. They're used interchangeably, and the third one is criminal. So that's civil, administrative, and criminal. The PLI provides defense and indemnity protection in the civil suits. It provides legal defense for administrative matters, and it provides legal defense for criminal investigations as well. I'm going to start out with civil exposures because this is the main reason that liability insurance for federal employees came about when Congress passed that legislation for agencies to reimburse employees who are classified as law enforcement officers, managers, and supervisors. It was because Congress truly appreciated that federal employees in these groups needed this kind of protection to have peace of mind to do their jobs, and they know they will be protected from complaints. They really want you to get this protection. Again, liability insurance is available to all full-time or part-time federal employees. It's just that Congress has identified this group, managers, supervisors, and law enforcement officers, as having the most exposures and risks. But that doesn't mean other positions that aren't in this category do not have similar risk and wouldn't also benefit from liability insurance as well. So these civil lawsuits, they're often referred to as Bivens actions, constitutional torts, personal capacity lawsuits, individual capacity lawsuits, and whatever they're called, they generally involve some very complicated legal principles. This is not law school. I'm not going to get into that today. But what I want you to take away is an understanding and appreciation that if you're sued, you can be denied DOJ representation and that you can be held personally liable even if DOJ represents you. You don't have absolute immunity for these personal capacity lawsuits like you do for lawsuits under the Federal Tort Claims Act. Okay? DOJ, again, the representation part, DOJ representation, believe it or not, is not mandatory and it is not automatic. So the Fed's policy will appoint you an attorney to defend in these personal capacity lawsuits when DOJ exercises its discretion not to defend you in the lawsuit. When does that happen? It most often happens if you're being investigated for some sort of wrongdoing for the very same reason that you're being sued. You can hopefully see that DOJ will not want to be on both sides of that case. The Fed's policy also will appoint coverage counsel to monitor DOJ's defense of you in certain cases, or if DOJ is on the fence as to whether they will defend or appoint you an attorney, the Fed's policy may hire what's called coverage counsel to convince DOJ to provide the defense. And finally, the big picture, the Fed's policy provides indemnity protection of up to $1 million or $2 million to pay any judgment if you are found liable and your agency denies indemnification. So it is those three concepts that I want you to take away: representation, immunity, indemnification. And an appreciation of what the liability, how it protects you in these three major ways. Provides a legal defense, we talked about the coverage counsel, and it actually pays damages. A final point I would like to make here before we leave our civil discussion is that civil suits without DOJ representation are actually rare, with actual liability being even rarer. Probably about 5% or a little bit less than 5% of the cases. If you've ever attended a liability seminar sponsored by your agency or the Department of Justice, an assistant United States attorney, and you sense that the instructor, the attorney, was questioning the need for liability insurance, it is because they look at it solely through the eyes and the perspective of a civil type of lawsuit, okay? Because they think it's such a small percentage, so why would you need to have to buy the insurance? They don't appreciate the other types of coverage it provides, the administrative and the criminal protections, and it doesn't take into consideration that it can happen, and it does happen. So no matter what the percentages are, why would you risk it at $135 a year if you're eligible for the reimbursement, or just $270 if you're not eligible? You will spend more than that for just 1 hour of legal service if you don't have the coverage. Like I alluded to just a little while ago, for most employees, the real exposure and real value of the policy is for this, what we call the administrative and criminal protections. The administrative provision of the policy, which I'm going to talk about now, covers all these types of inquiries and investigations. And I have found that federal employees often simply do not appreciate the seriousness of some of these investigations. You need to understand that whether your action is intentional or unintentional, the name of the game is accountability these days. The name of the game is accountability, and you will be held accountable for even the most trivial violations of agency policies. Allegations of wrongdoing can come from anywhere, and they're just a cost of doing business today, whether it's coming from the public, other managers, subordinates, other employees, Congress, politically motivated officials, or even your own agency. It's just simply the cost of doing business. And whether the allegations are true or false, most agencies are required to determine the validity of the allegation, which is going to begin with this investigation. And it's important for you to have your own legal counsel during these investigations. So the Fed's liability policy pays for legal defense for these administrative matters up to $200,000, and believe me, that's plenty of money to get you, what I call cradle to grave throughout the entire matter. So this covers you for any OIG investigation, OSC, OPR, Congressional, HR, management. Any investigation that could lead to a personnel action will appoint you an attorney to advise you and defend throughout that investigation process, and in the unfortunate event that there's a disciplinary action taken against you, we will defend both at the agency level and if there's necessary to appeal outside the agencies to such tribunals as the Merit Systems Protection Board, it will cover that as well. I should also mention that the administrative protections of the policy also apply to professional licensing entities that operate outside of the agency. What am I talking about? I'm talking about the state bar for lawyers, medical board for doctors, veterinarian medical boards for veterinarians, any professional licensing association, whether it's accounting or whatever, as long as it's arising out of your professional responsibilities, we will also cover that through this administrative provision. When should you expect an investigation? Well, you should absolutely expect an investigation if you're involved in a major event. Firing, injury, death, a failure in regulatory oversight, potential monetary loss, terrorism vulnerability, breach of national security. As most of you know, it's all about national security, and national security in post 9/11 means so much more. One particular investigation I want to just spend a little bit of time talking about is the Inspector General, the IG investigation. I can't tell you how many times I have heard, I didn't do anything wrong. And if I did, surely I can explain. Or if I show up with a lawyer, they'll think I'm guilty. The IG, which most federal agencies have one, investigates fraud, waste, and abuse and employee misconduct. And believe me, they like making cases against federal officials. And the higher level official, the more they're clawing at their desk. It's not to say that their role in government is not very important. If I have some of my IG friends on the telecast today, I want to make that point. It's just that we've seen a trend in them wanting to make cases at all costs and investigating matters that sometimes were above and beyond the original allegations. You know, when the weight of the federal government puts its magnifying glass on you, none of us are perfect. So you want to make sure you take these IG investigations seriously and get the legal advice that you need. To this point, it's important to be properly prepared for an IG interview by an attorney and also to actually understand what your rights are. Believe it or not every request for an interview is mandatory. Often they are voluntary, and submitting to a voluntary interview is also a waiver of your Fifth Amendment right, which should never be done without talking to a lawyer first. Another type of investigation I'd like to quickly mention is OSC, Office of Special Counsel investigations. Like the OIG investigations I just talked about, they should be taken very seriously as they could lead to a very serious disciplinary action if OSC determines that a prohibited personnel practice has occurred, or what's commonly known as a PPP. It's always important to get your own legal advice in these OSC investigations because while it may appear that your interests and the agency's interests are aligned and that the OSC investigation is really against an agency's decision, this is not always the case. And remember, the agency lawyers, their duty of loyalty is to the agency. That's their client. So they could be advancing an interest that's adverse to your own. So it's important to get your own independent legal advice, and the Fed's policy obviously covers that. The policy also covers you for any congressional oversight investigations or hearings. It could come from an informal request for testimony, formal subpoena. The Fed's policy also covers any kind of legislative commission, if you remember the 9/11 Commission, or similar other fact-finding matters if we determine that a personnel disciplinary action could flow from that. The final type of investigation I want to talk about, because I noticed that we have several managers and supervisors on the telecast today, there are EEO complaints. And I'm often asked, why do I need liability insurance or protection for an EEO complaint? Isn't it a case really against the agency? And isn't the agency really responsible to defend? Well, yeah, that's true. But you, as a responsible management official, are responsible for putting forward what's called the legitimate non-discriminatory reason for doing whatever you did or did not do. And again, like the OSC situation I just talked about, while the agency lawyers are going to be defending the case, and usually your interests are aligned 90% of the time, their duty of loyalty is to the agency. They do not represent you. So it's important to get your own legal advice. Also, I've found that managers are typically uninformed or unaware, and I know it's not their fault. It's the agency lawyers are not counseling them properly on what their role truly is in the EEO process. So the Fed's policy provides some coverage during the initial stages of any EEO complaint where it is alleged that you are the responsible management official. Here are some examples of covered administrative actions. I'll just take a second here and let you read through that on your own. These are real-world situations. These are, actual cases. Some of the facts are changed a little bit to, as they say, to protect the innocent. But these are real-world cases, and hopefully you can see, there by the grace of God goes any one of us. And finally, the last exposure area I want to talk about is your criminal exposure. Now, I know most of you did not come to work today intending to commit a federal crime. But as federal officials, you need to appreciate that there's very little you can do wrong in the federal government and not have it also be a violation of Title 18, which is the criminal code. Some of the most common criminal investigations involving federal managers usually involve conflict of interest statutes where intent is not a prerequisite to prove the crime, misappropriation of federal funds, release of Privacy Act or other statutorily protected information, or really any situation arising out of an allegation or misuse of position and authority. You remember I talked about the IG investigations. The IG agents that do the investigations are criminal investigators. So all their investigations are going to start with at least a look to see if they can make a criminal case first before it gets switched to an administrative type misconduct investigation. Here are some examples where federal officials and federal employees were subjected to a criminal investigation. Give you a minute to read through some of those. So this is just a slide, is just a recap as to what the policy covers, the administrative, the civil lawsuits, and the criminal proceedings. With hourly rates running for lawyers anywhere from $300 or obnoxiously $400 an hour for experienced lawyers, if you are forced to retain private counsel, you can see how quickly the legal fees can jump up. When I was an attorney in private practice, I witnessed people mortgaging their homes, depleting all of their savings, their TSP accounts, because they didn't have a liability and policy in place. You know, it used to break my heart that it would have just cost them either $270 or $135 a year, and they would have been fully covered. You wouldn't risk your house or car for insurance premiums. Why would you risk your job? Why would you risk your job? I should also mention here that the Fed's policy also provides 2 free half hours of legal consultation for things that are not necessarily covered by the core policy protections, or maybe it involves a pre-complaint matter. That alone, in my opinion, pays for the policy if you need to use that. And this is our final slide, and I can't emphasize the point that we're trying to make here is that you need to have the coverage in place before the incident happens. Just like your home insurance, your auto coverage, you can't get in an accident on Monday and buy your car insurance on Wednesday and think it's going to cover you. You need to get the protection in place first. It's easy to get signed up. It takes less than 5 minutes. You can go online at fedsprotection.com. We can send you a one-page enrollment form. You can give us a call. We'll do it with you over the phone. There's payroll deduction available if you want to spread the payment out. So there should be no excuse why you can't get enrolled today. This concludes my presentation, so we can now open the floor up to questions.
Okay, Tony, I have a question for you. This question is coming from a U.S. Forest Service employee. What determines who is a supervisor or manager? For example, official job description or the job you are performing. An example is you take a fire assignment and perform in a supervisory role for 2 weeks.
Yeah, that's a great question, and this answer is a little bit different for Forest Service employees as it is for employees at other federal agencies. In response to, I'm sure you're familiar with the 30 Mile and Kramer tragedies, the USDA was able to get special legislation passed that basically said if you're a temporary supervisor, you're eligible for the 1/2 reimbursement. So this means if you have the capability of being an IC, an incident commander on any type of fire, or be a supervisor, crew boss, whatever, on the fire, even if it's for a limited basis, you're supposed to be eligible for the insurance. Now, the Forest Service has done a good job of enumerating a laundry list of all these positions, and it's attached to their liability policy, and it's called Enclosure A. And you can get on our website and obtain a copy of it, or give us a call. We'll send it to you, or you can just call down to your central HR component in Albuquerque, New Mexico, and they should be able to provide you a copy of that. So it's an expanded definition for Forest Service employees who are working on fires. For other federal employees, it essentially means the manager and supervisor designation essentially means if you're ineligible to be part of a union, a collective bargaining union, because of your managerial responsibilities or your policy or your supervisory responsibilities, then you're eligible for the insurance. That's the definition that the public law pointed to for guidance.
Thank you, Tony. The next question is, does FDA cover half or any of the cost for feds protection?
FDA, federal, you say FDA?
Yes, sir, FDA.
Okay. Yeah. All agencies are required. All executive branch agencies are required to reimburse up to 1/2 if you can meet the designation of manager, supervisor, and law enforcement officers. Often, and then, many of the agencies that employ medical professionals, such as the FDA, VA, or HHS, there's a broader definition of supervisor and manager, and I really would advise you to consult FDA's policy on that. If you have trouble getting it, give us a call. We'll get a copy of it for you, and we'll interpret it together with you along with your position. It's meant to be liberally interpreted, that it's meant to apply to as many people as possible. Congress wants people to be protected in these situations. It's in the governmental interest for them to be protected. So the instruction is to interpret it as broadly as you can.
The next question is, what percentage of RMOs are sued personally as opposed to the agency is given in any given year?
Yeah, I understand the question. I understand the difference. A very small percentage of EEO complaints end up going as a personal capacity lawsuit. That's what we call these constitutional torts. EEO lawsuits are always going to be filed under Title VII of the Civil Rights Act and the federal sector EEO process. And that is always going to be a case against the agency, just like lawsuits under the Federal Tort Claims Act is always a case against the government, not you personally. So even if you're named personally, you're going to be, the government's going to substitute its name in those types of cases. So to be honest, 99% of the cases are all going to go strictly EEO. Your professional exposure, while it may not be financial liability, civil liability is accountability, job liability. In light of such laws and acts as the No Fear Act, increased awareness and scrutiny on accountability. If there's a settlement agreement on a particular EEO matter, or if there's finding of discrimination by either an final agency decision, administrative judge at the EEOC, or in federal court, you can bet that the agency is going to turn around and hold responsible managers accountable. And what does that mean? It means disciplinary actions. Agencies are required to report to the EEOC and to Congress all the findings of discrimination and certain types of settlement agreements. And they're also supposed to report what disciplinary actions they took against the offending managers along with that. They're not going to report 10 findings against them and no disciplinary actions. It's just not going to happen. This is, again, like I keep using the phrase, the cost of doing business. So that's why the policy is important to come in and hopefully assist you in putting forward the best possible case for the agency to defend with.
Thank you. Another question is this the only available liability insurance? If not, why should we purchase this particular policy instead of another?
There are essentially two other major providers. One is called Right USA. Another is called Mass Benefits, or their branding is Career Guard. The core protections, the $1 million to $2 million, the legal defense for administrative and criminal, are by and large identical or very, very similar. The reason that we think we're above, and you should consider us over these other companies, and we would encourage you to do your own comparisons as well. And also, if you get on our website, we've got some information and document on there that specifically goes down and enumerates all the significant differences. And I'll quickly do that for you. First of all, legal representation is not capped for civil matters at the sublimits. You get the full $1 million or $2 million to fully defend against a civil case. Other policies tend to cap that at the sublimit of $200,000. We have no clawback provision. This operates other policies. If you're covered for a criminal matter and you're ultimately determined guilty, they have the right to come after you for legal fees. We do not have a similar clawback provision. Claims handling, we have an independent third-party company that does all the claims administration. This is determining what's covered and what's not covered. Other companies do that in-house, so there's an appearance issue of a conflict of interest there. We don't do that. There's premium savings, these free consults that I talked about earlier. We don't charge extra for. Other policies charge extra for these extra endorsements. We give pro rata refunds. They do not. This is when you leave or retire from federal government. We've got no unnecessary administrative fees. But having said all that, the real two things that are the most important are the quality of our legal defense and our commitment and know-how in-house. First, the legal defense. The lead panel is Shaw, Bransford, and Roth. For over 25 years, they've been the leaders in federal personnel law and defending federal employees. I would encourage you to look them up. They're second to none. And then our commitment and know-how. We're involved in your community. I'm a former federal employee. We're trying to run a program that really does right by federal employees. We're not here just to sell you insurance. We really are concerned and want you to get the protection you need. When I founded this company, it really was on a platform of education because I really felt there was a high percentage of federal employees who simply were not aware of what the coverage provided. I would encourage folks to, again, get on our website. You can see that all the leading federal employee associations are endorsing us over all other providers. I would just suggest that there's a reason for that.
Tony, this lady has her hand up, and I believe she has a question. I'm going to unmute her. Her name is Karen.
Hi, Karen. You have a question?
Okay.
I can't hear.
Sorry about that.
Asking. Don't worry. This is live TV.
All right. It looks like we might be out of questions, Tony.
Okay, I want to thank everybody who stayed on. I obviously went a little longer than the 15 minutes, but hopefully you found it valuable and obtained the necessary information that you were looking for to make a informed decision on whether you need liability insurance or not. Thank you.